Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. I am going to get to talk about perhaps one of the most rare occasions that we ever could possibly talk about here at Washington Gun Law. This is as rare as a unicorn that craps ice cream. But you're not going to believe what just happened in the Ninth Circuit. Now, we're going to explain it to you because once you see what happens, you're probably like, oh, that doesn't totally shock me for the Ninth Circuit. But today, let's go through the ruling. We'll geek out for a little bit. We'll try to explain what's going on. So let's talk about, wait, the Ninth Circuit strikes down a gun conviction? Okay, America, gonna get to do something I never thought we'd get to do. We've been doing this channel for a little over 4 years now, and today we're gonna get to talk about the Ninth Circuit striking down a federal gun conviction. The case is United States of America v. Metcalf. It comes to a 3-judge panel out of the United States District Court for the District of Montana. The 3-judge panel consists of Justices Schroeder, Owen, and Van Dyke being the author of this opinion. Now, Mr. Metcalf liked to patrol around his home with a shotgun on public sidewalks with a grade school in very close proximity. Local police decided to pay him a few visits, and although they paid him a few visits, they acknowledged that he was never violating any law and never cited him for anything. Mr. Metcalf was still upset, so he figured the better thing to do would be to call the FBI and complain about local Montana police harassing him, which then got the ATF involved, and they ultimately ended up citing Mr. Metcalf with a violation of the federal gun-free zone law found in 18 United States Code Section 922Q. Mr. Metcalf raised a couple of arguments, only one of which involved the Second Amendment, and will not be addressed here because it was not addressed by the Ninth Circuit either. But Mr. Metcalf did claim that he was exempt under the federal gun-free zone law, specifically 18 United States Code Section 922Q2B sub 2. And he fell under that exception because of Montana Code Section 45-8-360. So what we have is a conflict here between a federal statute and a state statute. Now, the federal statute, which makes it a crime to knowingly possess a firearm within a gun-free zone, has an exception. And that exception is found in 18 United States Code 922 Q2B sub 2. Say that 5 times fast. But that applicable section reads, this law does not apply to the possession of a firearm if the individual possessing the firearm is licensed to do so by the state in which the school zone is located or a political subdivision of the state, and the law of the state or political subdivision requires that before an individual obtains such a license, the law enforcement authorities of the state or political subdivision verify, pay attention, that word right there, verify that the individual is qualified under law to receive the license. Okay, so if Mr. Metcalf is properly licensed by his state, he's exempt from the statute. Okay, what's the problem? When we take a look at Montana Code Section 45-8-360, we will see that because Montana is a constitutional carry state, what they have done is drafted a statute that reads as follows. In consideration that the right to keep and bear arms is protected and reserved to the people in Article 2, Section 12 of the Montana Constitution, a person who has not been convicted of a violent felony crime and who is lawfully able to own or possess a firearm under the Montana Constitution is considered to be individually licensed and verified by the state of Montana within the meaning of the provisions regarding individual licensure and verification in the Federal Gun-Free School Zones Act. Okay, so what this all comes down to is, what does verify mean? What the federal government is arguing is that there must be some affirmative steps taken to actually establish that the person is in fact lawfully allowed to possess a firearm. The state of Montana says we're going to assume that everyone is unless it's proven otherwise. What the federal government argued is that Montana's law was not sufficient. But even though the federal government did not believe the law was sufficient, Nobody, including Mr. Metcalf, was ever put on notice, which brings us to the two ridiculously legal theories that we're going to have to geek out today, the first one being the rule of lenity. I have actually used this as a criminal defense attorney. This is what the rule of lenity says. The rule of lenity is a principle in criminal law where any ambiguity in a statute is resolved in favor of the defendant. It requires that criminal laws be clear enough to give defendants fair warning of what is prohibited, thereby upholding the constitutional right to due process and the separation of powers between the legislature and the courts. So what it really comes down to is if a statute is subject to two reasonable interpretations, the interpretation that must be adopted is the one offered by the defendant. It leads the court, as the Ninth Circuit ruled here, to make a ruling that states, we agree that the district court's reading of section 922 Q2B2 is the better reading of the statute, but we do not agree that this reading is the only plausible reading or that the statute is unambiguous. Metcalf also offers a plausible reading. Okay, so they're both offering plausible explanations here, right? And under the rule of lenity, that means the court has to adopt Metcalf's. And Metcalf's basically says the state statute says I'm presumed to be verified. You all agree that I am actually eligible to possess a firearm, and therefore, for purposes of both state and federal law, I am in fact verified. And if the United States actually had doubts about whether or not I truly was verified or exempt under the statutory exemptions here, well, they never notified me, which then brings us to the next geeky legal theory that we have to go over, which is the presumption in favor of Scienter. I have never actually used this terminology, although I have used arguments quite similar under different labels. What this means is that when you take a look at the statute, it says a person possesses. Now, if you take a look at what possession means, it means to knowingly be in control of something, okay? So even though there's not a mental element, or what the legal geeks call mens rea elements, written into the statute, there still needs to be a willful act. But according to this legal theory, the presumption in favor of Scienter is a legal principle stating that for a criminal statute to be valid, the government must generally prove a culpable mental state or mens rea for each element of the offense that criminalizes conduct that might otherwise be innocent. This presumption applies even if the statute doesn't explicitly mention a mental state or contains a general Scienter provision. So what the court said is listen, because this activity could be legal or could be illegal, and you never notified him that it could be illegal, and he has to knowingly be in possession of a firearm which is in violation of the law, you don't have a case here. So between the rule of lenity and the presumption in favor of Scienter, a three-judge panel of the Ninth Circuit has ruled, affirming Metcalf's conviction would thus not only run afoul of the rule of lenity's cautions, but would undermine the principles underlying the Supreme Court's decision in previous cases and the presumption in favor of Scienter. We therefore conclude that the district court erred by declining to dismiss Metcalf's indictment. Accordingly, the district court's order denying the dismissal of Metcalf's indictment is reversed, and we remand this case with direction to dismiss the indictment. Okay, so where does the case go from here? Who knows? The United States Department of Justice could seek review to a full en banc panel of the Ninth Circuit. God only knows what's going to happen. This was one of the tougher cases to actually break down and try to make it mildly interesting and entertaining. I hope we did our job. Let us know down in the description box. Okay, the case once again is United States v. Metcalf. We're going to link that ruling up down below so that you don't have to take our word for it. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that information's down there in the description box. If you got an idea for a video, you click on that link. You guys know the drill. If you want to subscribe to the monthly newsletter, that's down in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.